Hello, everyone. My name is Julian Sanguidolci, and I work on the client-facing team at CFRA. I would like to welcome you to today's webinar entitled Technology Platform Legal Risks, GDPR, Antitrust, and More. Before we get started, I wanted to remind you that today's session is being recorded, and the link to the recording will be made available within the next few business days. During today's session, you may submit questions using the GoToWebinar panel, and we will do our very best to answer as many of these questions as we can. During today's session, my colleague Nick Rodelli will review case studies of legal, regulatory, and policy risks across the 4 dominant U.S. top technology platforms: Alphabet, Amazon, Apple, and Facebook. We'll review the strategies you can use to model legal risks for each of these 4 dominant technology platforms and discuss the positive and negative catalysts that could trigger repricing of the stocks. In addition, my colleague Scott Kessler, Director of Fundamental Equity Research at CFRA, will provide insights on these 4 technology companies from a fundamental perspective. Finally, we will provide an overview of CFRA's unique process to analyzing legal events, categorizing key issues by probability, and then analyzing those issues on a company-by-company basis. Our clients consistently tell us legal situations are severely undercovered by sell-side research. That's why CFRA Legal Edge partners with institutional investors to understand legal and regulatory risks related to public companies and leverage this insight to formulate both long and short investment ideas based upon legal outcomes. Very briefly, for those of you who may not be familiar with CFRA, our firm is focused on identifying companies using accounting tricks and opaque legal disclosures to hide underlying operational deterioration. We provide both accounting, legal, customized, and industry insights to help our clients make more informed decisions. Specifically, our legal team helps clients understand legal implications and how that could be a positive or negative catalyst for the company under coverage, as Nick will detail today. Before we dive in, I'd like to provide a quick overview of Nick and Scott's professional backgrounds. Nick is the founder and head of CFRA's Legal Edge product, having joined the firm in 2006. Prior to joining CFRA, Nick worked with several major law firms as a litigator and corporate governance counselor and as a merger arbitrage and special situations analyst at a multi-strategy hedge fund. Scott Kessler is a director of fundamental equity research at CFRA. In addition to managing a team of industry analysts, Scott is responsible for fundamental analysis and valuation assessments within the internet, software, and fintech areas. Prior to CFRA's acquisition of S&P's equity research business, Scott held the position of Deputy Global Director and Industry Analyst for S&P's Global Market Intelligence Group. And with that, Nick, I shall hand it to you.
All right. Thanks, Julian, and good morning, everyone. We've got a lot of ground to cover in the next 30 minutes or so as the very unofficial opening act for Apple's 1 p.m. event. That's a joke, folks. So I'll jump straight in. To begin with a little bit of background, in January of this year, we started to get client inbounds around tech platform legal and regulatory risks. The Facebook Cambridge Analytica event in March obviously accelerated that trend by showing how these issues can impact stock prices. Rather than responding to each new headline, we tried to take a step back and come up with a more systematic approach for assessing tech platform legal risk. Our methodology includes looking across key categories of risk, such as privacy, antitrust, and policy, then identifying specific risks within these categories, and finally, allocating those risks to one of 3 different probability-based buckets, including highly probable, or greater than 70% odds, reasonably possible, or 40 to 60% odds, and low risk, less than 20% odds. We published an initial report on this subject this past May. So beginning with a high-level view of our three buckets. In the highly probable category, we see high odds that strategic M&A by major platforms either won't get done or won't even be attempted. Battles over interpretation of GDPR and other privacy laws, and new regulatory inquiries by the US FTC and DOJ, the EU, and state attorneys general. In the reasonably possible category, we include aggressive interpretation of current US laws that are already on the books, new federal privacy and data legislation, and new government lawsuits. Finally, in the low-risk category, we include the US DOJ or FTC actually bringing a lawsuit to unwind a closed merger, or substantial changes to US copyright or antitrust law. And then we see the tail risk of regulating tech platforms as utilities or common carriers. Moving now to the three risk categories and looking first at antitrust in the M&A context, there's an emerging view among antitrust lawyers, academics, and even regulators that tech M&A has gotten too much of a free pass in recent years. Network effects and the benefits of scale mean that even small deals can be anti-competitive. So for example, there's a good chance that a deal like Facebook's $1 billion acquisition of Instagram in 2012 wouldn't get approved by regulators today. As to non-M&A antitrust enforcement, obviously Europe has been much more active than US regulators, with lawsuits against Google for shopping on Android, Facebook for misrepresentations around the WhatsApp deal, and Amazon for ebooks. This is partly due to more flexible legal rules in the EU than in the US. In the US, there seems to be, at this point, some increased openness to at least asking questions regarding antitrust and tech platforms, although regulators have rightly stressed the need for analytically supported theories of harm as opposed to big is bad rhetoric that's untethered to economic evidence. But the contrast between the US and EU regulators remains very stark. While the EU is studying whether technology platforms should be considered essential services and thus regulated as utilities, we're not aware of any formal antitrust-related investigations by either the US DOJ or FTC at this time, but more to come on that a bit later. So switching gears to data and privacy, there's GDPR and its lesser-known cousin, the California Consumer Privacy Act of 2018. GDPR went live this past May 25th, while the California privacy law, which was passed in late June, is scheduled to go into effect in January of 2020, although lobbying is underway to further delay the effective date. Beginning first with GDPR, we see several hot-button interpretive issues that will play out in the months and maybe even years ahead. This includes whether consent for the use of personal data is freely given, and the leverage platforms can bring to bear to encourage consumers not to opt out. We view the California privacy legislation, passed just over 2 months ago, as somewhat of a sleeper as compared to GDPR, likely due in part to its delayed effective date. But as that law in California stands today, we view it as potentially more impactful than GDPR for a few reasons. First, it could be the canary in the coal mine that even blue state tech-savvy voters want major privacy reform. Second, the law bans charging opt-outs a different price or providing opt-outs a different level of service, unless these differences are reasonably related to the value of the consumer's data to the consumer. So as the law stands, it would be hard for Google or Facebook to discriminate in any way against opt-outs. The tech industry reportedly is working to change the language of this rule to allow for price or service quality discrimination against opt-outs. Third, the law in California targets artificial intelligence and algorithms that can make inferences and identify tendencies with partial data. This would appear to broaden the definition of personal information to a degree that might inhibit targeting of any kind, even when sensitive personal information isn't used. So moving now to the third major risk area, the potential for new federal legislation. Major new U.S. antitrust legislation is unlikely in our view. The American antitrust establishment generally agrees that the DOJ, the FTC, and private parties have sufficient tools under existing law to address tech platform conduct that negatively impacts consumers. While we think there's a fair argument that U.S. antitrust law is in need of reform, in part because of an overemphasis on short-term price effects as proof of harm, we're pretty skeptical that it will happen anytime soon. And major tech platforms can take comfort in the U.S. Supreme Court's recent American Express decision, which set important platform-friendly precedent in the context of two-sided markets. More likely, in our view, is federal data protection and privacy legislation. It's important to note here that federal legislation would trump state law. Thus, we'd expect that federal privacy legislation will be a major battleground between the tech industry and privacy advocates. A tail risk here, in terms of a new U.S. law, would be major changes to the Digital Millennium Copyright Act or the Communications Decency Act, which some argue allow technology players to evade responsibility for content hosted on their platform. This, among other things, would expose tech platforms to significant liability for copyright violations. Facebook included a new risk disclosure on this very issue in its latest 10Q. And across the pond this morning, the European Parliament passed new legislation whose aim is to make sure that content creators are fairly compensated. And this was passed over the objection of the U.S. tech industry. We await the details on that legislation, but see it as a potentially significant development. In addition, other policy options have emerged recently. Senator Mark Warner's white paper, discussed at last week's Senate Intelligence Committee hearing, has several proposals that could usher in new competition or limit the use of personal data. One proposal would give users granular information about the value of their data to their respective platform. The proposal could be particularly powerful if it's coupled with strong data portability and opt-out rules. Now moving to from the general to the specific, I want to run through a few thoughts on how these issues can impact each of the major platform players. First up is Alphabet. At a high level, Google probably has a deeper and more distinguished track record of dealing with legal and regulatory issues and risks than any of the other platform players. Google fought off Steve Jobs' patent litigation attack, Larry Ellison's copyright challenge to Android, although that's still ongoing, and lawsuits challenging Google's auctioning of trademark keywords and Google's copyright policies. And obviously, Europe has been investigating and bringing cases against Google for many years at this point. So dealing with these issues is kind of part of Google's corporate DNA. As to antitrust specifically, we think Google's search monopoly is so entrenched that increased antitrust scrutiny in the M&A context just really probably doesn't matter. We're also skeptical that Google will be regulated as a utility in the US or otherwise forced to restructure, at least for the foreseeable future, although again, the EU is exploring this topic. All of that said, search bias, and here we mean specifically the biasing of Google search results to favor Google commercially at the expense of competitors, is a sensitive subject and an area to watch. We think that if regulators get under the covers of Google's algorithms, all bets could be off. Also, we think Google's decision not to send Larry Page to Washington last week was a mistake and might suggest that Google's tone deaf and doesn't fully appreciate shifting public and political perception towards tech platforms. As to data privacy, given the user-directed, intent-based nature of traditional Google search. There appears to be less risk to Alphabet than certain of its peers. That said, YouTube is an important source of growth, and ads on that platform reportedly are more linked to personal data than user intent. Also, Google reportedly has adopted data collection and tracking practices of peers like Facebook, so Google's risks on data and privacy might be more complicated than first meets the eye. As to GDPR and other privacy laws, we expect Google to take a minimalist approach to compliance, especially on key interpretive issues that actually move the needle for the business. Similarly, we'd expect Google to lead the charge to water down or preempt California's new privacy legislation. This is why politics and public perception are particularly important and bear careful watching, as it will be more difficult for the tech industry to shape legislation to the extent public sentiment sours. But again, overall, at least as of today, we're fairly sanguine about Google's risks, given their entrenched search monopoly and the lack of any appetite here in the US to create new utility-style regulation. We think Google's softest spot, again, is this issue of favoring its own properties in search results. And we've become more concerned to the extent Google search algorithms come under closer scrutiny. Moving on now to Amazon. In some ways, Amazon seems almost purpose-built to avoid the reach of US antitrust law. US antitrust law, again, it focuses on short-term price-related impacts and basically assumes that it's illogical for a company to take short-term pain in order to reap long-term market share gain. This aligns hand in glove with Amazon's business model, entering new business lines, crushing margins, and bringing lower prices to consumers and business customers. That said, Amazon's valuation can be seen as a bet by investors that the company will recoup its massive investments and substantially lift margins over the long term, and will rinse, wash, and repeat this model as it enters new lines of business. Thus, while Amazon faces lower absolute risks than peer platforms Google and Facebook, there's a fair argument that Amazon's share price has more significant downside re-rating risk on any adverse shock. We'd note that in an April 2018 speech, DOJ Antitrust Chief Makan Delrahim referenced work in the form of an academic paper entitled Amazon's Antitrust Paradox, and seemed to suggest that the DOJ will at least consider serious claims of injury to competition by means of predatory pricing. Another area where we believe Amazon could be vulnerable is in the company's high-margin Amazon Web Services business, including claims that AWS copies ideas from vendors that sell their services through AWS. In addition, although less impactful to Amazon's bottom line, there could be issues on the retail side, including that Amazon's access to vendors' sales and other data allows Amazon to pick off in-demand products and then sell them directly through private label. Another issue are the fees charged to third-party sellers and differential treatment of those sellers in product placement, depending on their degree of uptake of Amazon's high-margin merchant services. Amazon also has some exposure, in our opinion, to the data and privacy issues swirling around Facebook and Google. The company's rapidly growing high-margin ad business is said to be particularly savvy at leveraging the wealth of purchase data Amazon has on its customers. We think this area could garner more attention in the months ahead. The bottom line here is we see pretty good odds that Amazon will face an FTC or DOJ investigation in the next year or so. Next up, Apple. Of the four platforms, we view Apple as having the lowest absolute data privacy and antitrust risk. That said, we think Apple has at least some modest antitrust exposure and business risks in its services business. With respect to data and privacy, Apple doesn't appear to benefit directly from ads gleaned from user data. Apple, of course, hasn't been shy about contrasting its business model from peers such as Google and Facebook. where in the latter cases, according to Apple CEO Tim Cook, you, or specifically your data, are the product. On the antitrust side, Apple could be vulnerable to claims that it doesn't treat app providers fairly. This is particularly the case where Apple has a directly competitive offering with a given app provider, such as Spotify. This could become a larger issue as Apple launches new offerings and seeks to build out its services business and increasingly competes with app providers. Along those lines, we'd note recent testing by Netflix, designed to avoid paying Apple its 30% cut of revenue by having customers sign up or reset their account directly on Netflix's website. We wonder whether Netflix's willingness to poke the bear, so to speak, may hint at Apple's vulnerability in this area. More generally, we question the sustainability of Apple's 30% cut of app revenue, or 15% for subscriptions after year one, figures that are particularly notable when contrasted to Apple's refusal to pay Qualcomm contracted patent royalties in the 2 to 3% range. Given that Apple's high-margin services business is now of increasing importance to Apple's bull case, we see this as an important area to watch. Now on to Facebook. In our May Tech Platform report, we wrote that investors' concerns regarding sustainability of Facebook's long-term cash flows were probably justified. We flagged the company's new warning in its Q1 2018 10-Q that changes in data collection practices, quote, will reduce marketers' ability to effectively target their ads, which will adversely affect the company's ad business. We thought that this was an unusually blunt and pointed warning from the company. Facebook's Q2 F18 results and lowered guidance validated our concerns, with the company indicating that it is, quote, giving people more choices around data privacy, and that might inhibit revenue growth. Facebook also said that expense growth will outstrip revenue growth over the next several years, in part due to spending to make Facebook's platform, quote, more safe, with operating margins expected to trend towards the mid-30s from their current 45. From here, we think that much of the story for Facebook on data and privacy turns on, again, interpretive battles over GDPR and other privacy laws, the fight to change or override California's new privacy law, and the potential for new regulation or new legislation. The company's Q2 F18 10-Q included new warnings regarding California's privacy law, this fall's elections, uncertainty regarding advertisers' own legal and compliance obligations, and legislative proposals that could put Facebook on the hook for copyright infringement that takes place on its platforms. All of that said, we would argue that concerns regarding Facebook so far are driven almost exclusively by data collection and privacy issues with little to no concerns regarding antitrust. However, we wonder whether Facebook's market dominance is less entrenched than certain peer platform players, and thus more vulnerable to disruption by a new social media entrant or alternative data collection-based ad model. If that's right, then the shift towards more scrutiny of tech platform M&A might disproportionately impact Facebook. Okay, so the next topic we explore is the extent to which the risks we've been discussing may be priced into platform company share prices. In our experience, an assessment of multiples across a very broad range of metrics, earnings, cash flow, EBITDA, sales, PEG ratio, etc., can help illuminate, at least directionally, whether a risk premium is baked into a company's share price. We acknowledge this is not a precise exercise, and of course, that a range of factors unrelated to legal risk can and do influence multiples. That caveat aside, what we see in looking at share price performance and multiple expansion and contraction since the Cambridge Analytica event on March 18th is interesting. A few observations. First, Amazon and Apple appear to have not only gone unscathed, but may actually be a beneficiary of increasing concerns regarding Facebook. as asset managers perhaps rotate into perceived lower risk mega cap tech platforms. Second, the negative impact on Facebook comes through clearly in our view, as investors implicitly have built a meaningful risk premium into Facebook's equity price. Third, the impact on Google is a much tougher call, although Google's share price has noticeably underperformed in recent weeks, perhaps suggesting that investors are starting to look at Google's risks in a somewhat similar light to Facebook. Overall, with the possible exception of Facebook, we'd argue to date, there's only been a modest pricing in of these risks. We also note here the potential for a potent mix of both increased risk premia and negative impact on growth and expenses. Next up is secondary effects, moving beyond the four platforms to potential downstream winners and losers. And we're seeing an impact in this area already, in particular with respect to data and privacy and GDPR. So on the positive side, it seems clear that GDPR and California's new privacy law will bring structural benefits to security companies such as Palo Alto Networks. Both laws use carrots and sticks to encourage companies to carefully protect consumer and business data. Under California's law, for example, class actions can be brought with penalties of $750 per incident per consumer, where personal information is stolen due to failure to maintain, quote, reasonable security procedures and practices. We believe companies with the resources to do so will increasingly adopt best-in-class security solutions to limit liability and adverse publicity. To update an old saying, nobody gets sued for using Palo Alto Networks. Also on the positive side, web marketing companies such as Trade Desk that reportedly do not use directly identifiable personal information may benefit, as advertisers look for lower risk ad measurement and analytics platforms. On the negative side, several companies already have cited GDPR and privacy issues as contributing to disappointing financial results, including Nielsen and Publicis, among others. We expect to learn much more about the fallout from privacy issues and GDPR as we get the first full quarter's impact in the third quarter. Now moving on to upcoming events and some key issues to watch. We begin with potential new regulatory inquiries. We recently served Freedom of Information Act requests on both the US FTC and DOJ to try to uncover the existence of any new investigations. So far, we have no reason to believe there are any existing formal antitrust-related investigations of any of the four platforms at either the DOJ or FTC. Now, this leaves to the side the FTC's publicly announced investigation of Facebook, specifically the FTC's consumer division. But there is a lot of tire kicking going on. That's quite clear in terms of studying competition issues broadly as applied to platforms. And we think that this tire kicking, so to speak, is a precursor that is reasonably likely to lead to company-specific inquiries. And it's just a matter of time that we'll see that. A second area to watch is implementation issues around GDPR. Again, a key issue here is what it means for consent for the use of personal information to be freely given. Related to GDPR, efforts to water down or override California's potentially impactful privacy law is obviously important as a bellwether for what could spread across the U.S. Midterm elections in the United States this fall could also prove important for several reasons. To see how the ad platforms weather increased transparency of political ads and public opinion regarding impact of those platforms on elections, as well as the actual outcome of elections. We also view EU Competition Commissioner Margrethe Vestager as an important player to watch, as she's been the point of the spear when it comes to antitrust and large tech platforms. Finally, we have very little at this time to go on in terms of the US FTC's enforcement priorities and the view of the FTC's new chair, Joe Simmons, when it comes to antitrust as applied to tech platforms. We note that the US FTC has very broad authority under Section 5 of the FTC Act to bring cases targeting, quote, unfair methods of competition, perhaps signaling an openness to at least consider a more aggressive enforcement agenda. The FTC has announced a series of hearings that will take place throughout this fall and kicks off tomorrow at Georgetown University's Law Center. One particularly notable hearing will be held October 15th through the 17th at George Mason's Law School, and will cover the identification and analysis of collusive and predatory conduct by digital and technology-based platform businesses, and also will look at the antitrust framework for evaluating acquisitions of potential or nascent competitors in digital marketplaces. We'll also be attending what we think is the most important annual gathering of global antitrust regulators, lawyers, and corporate executives on September 25th in Washington. We attend this event every year and glean important insights as to both broad trends and company-specific antitrust issues. I'll now hand the podium over to my colleague, Scott Kessler. I'll be back with a few brief concluding points before we move into Q&A. Scott?
Thanks, Nick. Nick did a great job of going through a variety of the many legal and regulatory issues some of the major technology platform companies are facing. Already, there have been notable fundamental impacts on these companies. For example, Facebook and Twitter highlighted the negative effects of Europe's GDPR on users in the second quarter. And the new law was only implemented in late May, more than halfway through the quarter, suggesting to us there may be more related challenges to communicate. Accordingly, with fewer users than otherwise would have been the case, revenues were restrained. In fact, Q2 was only the second quarter over Facebook's 25 quarters reported as a publicly traded company when it missed the consensus revenue forecast. I want to mention that CFRA was positively recommending Facebook shares from April 2014 into late June of this year. But after the stock established new highs, even with new and seemingly increasing risks related to Cambridge Analytica, we downgraded to hold on June 27th. Additionally, on July 9th, we downgraded our opinion on shares of Twitter to sell, citing concerns about users and revenues. We upgraded to hold after a significant decline following Q2 results. Many were surprised by the negative impact of GDPR on users and revenues. However, we think many had been anticipating the negative impact of legal and regulatory scrutiny, oversight, and actions on these companies. Recently, Alphabet had to account for its second multi-billion-dollar EU fine in a little over a year. Facebook has been focusing on adding thousands of employees to help ensure its platforms are safe and secure. And Twitter has been purging tens of millions of accounts over the last couple of quarters. Although Nick detailed different risk-related takeaways for these technology platform companies, we expect all of them to be relatively conservative in terms of expansion and M&A efforts, consistent with what Nick communicated earlier. Frankly, they just don't want to be perceived as antagonizing regulators and have important actions delayed by many months. For example, we note that about 9 months ago, Apple announced plans to buy music identification company Shazam, and they only just received EU antitrust approval for a purchase essentially amounting to 0.04% of Apple's overall market cap. So clearly this is a relatively minor transaction for Apple, but it's going to take the better part of a year for the deal to be completed. On a related note, we see opportunity for Spotify as the major technology players may be less aggressive in their moves in the global music streaming market. And it's probably relevant to point out that we initiated coverage of Spotify with a buy opinion a month or so ago, and we retain that opinion today.
With revenues, margins, and growth being restrained by legal and regulatory overhangs, we see technology sector companies like Alphabet, Facebook, and Twitter experiencing valuation declines and multiple compression, consistent with what Nick communicated earlier. We know congressional hearings last week focused on social media and talk about DOJ and attorneys general meeting about this subject later this month. I think it's fair to say that the drumbeat related to legal and regulatory concerns and actions will continue. Given a bright regulatory spotlight and uncertainty about more aggressive spending, we expect some of these technology platform companies to perhaps become even more aggressive with stock repurchases, especially following U.S. tax law changes at the end of last year. This is especially relevant for the larger companies with more liquid balance sheets. With that, let me revert back to Nick Rodelli for some concluding thoughts before we move to Q&A.
All right, great. Thank you, Scott. So yeah, now just very quickly, 3 final concluding points before moving on to Q&A. So first, obviously we don't have a crystal ball, but we do think it is significant that at a very high level, we're moving from an almost uniformly positive view of tech platforms and their contribution to society to something much more nuanced and two-sided. We think that the range of outcomes for tech platforms, even for entrenched monopolies, is widening. So far, only Facebook's valuation appears to reflect that new sense of uncertainty in our view. It should be remembered that antitrust and other interventions, such as new laws or regulation, are largely a question of will, not a question of ability. And political wins and enforcement priorities can shift quickly. So what we call a tail risk today could rapidly turn into a base case. The second point is that data privacy concerns are structural and they're real. Reported financial results, as discussed from Facebook, Nielsen, and others, already bear this out. So suggestions that GDPR is this year's Y2K or is a lot of sizzle but no steak have already been proven wrong. The good news is we think the movement towards what's increasingly being called ethical data will create significant investment opportunities, long and short. The last point is, today we don't have an actionable thesis on any of the 4 major platforms, but we stress that that could change in the weeks and months ahead as we monitor the different risk vectors. That's it for our prepared remarks, and we'll now move into Q&A. Julian?
Thank you, Nick. Fantastic presentation by you and Scott. We already have a whole slew of questions that have came in here, so let me hop right into it. Nick, the first one is for you. If you had to list the top 3 actions regulators or lawmakers could take in terms of impacts, what would they be?
So I think the top of the heap would be utility-like regulation or structural breakup, suing to unwind a closed merger, for example. Again, that seems to be very unlikely, at least in the United States anytime soon, but it would be obviously a very large impact. The second thing I would list is data value transparency, referred to earlier in the Senator Warner white paper, particularly if that is coupled with data portability. That would also align with the views of DOJ Antitrust Chief Makan Delrahim. He has made comments in public speeches that suggest that he thinks a market solution around data value transparency could be a way to increase competition in this area. The third thing I would put on the list would be this is just general ability to opt out of collection and use of personal data without any discrimination, and that's the key part. Can you do so without really any kind of downside as a consumer? We think that that is the way the rule reads now in California, at least as it stands. So that's something to watch. So overall, I'd say that of these three, the one that's most interesting, both from the standpoint of probability of happening and something that could be very impactful but isn't garnering much attention, is data value transparency.
All right, we have a whole slew of other questions we'll hop right into. Next, are there emerging distinctions between the use of sensitive personal information such as name, email, social security number, etc., and other information?
Yes, definitely. There seems to be more risk, including more robust consent requirements for more sensitive personal information. It's a dichotomy that seems to be playing out. So if you have aggregated data that is kind of untethered, not linked to personal information, that appears to be kind of on the lower risk side of the spectrum. There's some ambiguity in the middle. So for example, under California's new privacy law, the use of AI or algorithms to match data with a particular individual appears to be treated as sensitive personal information and would require consent, et cetera. But the bottom line is that the farther away the business model is from the use of sensitive personal information, the better, at least from a risk perspective.
Next question that just came in. Can you give us a sense for the kind of situations you cover, do not cover, and how do these situations come on your radar?
So my team, we're generalists, and we aren't limited in any way by legal subject. There are a few exceptions, areas that we don't tend to get into. We avoid, for example, chemistry intensive patent litigation, and we stay away from distressed and bankruptcy. There's plenty of people that do that well. But otherwise, we're pretty opportunistic. So we have a pipeline of cases. We publish that to our clients, and we watch those cases as they kind of move their way through the legal process, and eventually make decisions on which ones to put more investment into in terms of time. We do focus on judge-based decisions, so either appeals or non-jury trials. An example right now is the Acorn-Fresenius merger litigation in Delaware. We tend to stay away from jury trials, given their inherently speculative nature. One juror can change an outcome. We also tend to look at situations in terms of an idea source where we think legal issues and fundamentals are tightly linked. A few examples currently, you have the Qualcomm-Apple licensing and litigation dispute, where, quite clearly, from everything from revenue and profits to the timing of buybacks for Qualcomm, we think is linked to Apple-related developments. And then in the healthcare space, we're actively covering litigation between the FTC and Henry Schein and Patterson, and we think there as well that antitrust issues are playing a part in fundamentals.
Next question. What kind of investment strategies utilize your work, and can you help us understand the market cap sectors you focus on?
Sure. So we have a pretty diversified client base. So we have everything ranging from traditional asset managers, long short equity, event-driven hedge funds, and law firms, to cite a few. Our content includes ideas of varying time frame, varying duration, along with kind of at the outer edge of that, thematic work that is obviously more kind of longer term oriented. In terms of sectors, we tend to have more coverage in TMT, just broadly defined. There tends to be more material, legal and regulatory issues, and business models rise and fall more quickly in our experience in that sector. So we do tend to have more coverage there. However, we typically have ideas that span most, if not all, sectors at any given point in time.
All right, we have a couple more questions targeted towards our fundamental view on this situation. So Scott, I'm going to target these towards you. The first question is, what are your equity recommendations on the stocks of the platform companies referenced throughout the presentation?
Yeah, thanks a lot, Julian. So I alluded to a couple of those. So I think in Europe, they refer to these companies as GAFA. So the G stands for Google. Alphabet, we actually have a buy opinion on. But I think it's important to reference the fact that we downgraded the stock to buy from strong buy. I think it was on July 24th. In terms of Apple, we have a buy opinion on that stock. That's been a very, very good call for us. Remember, a couple of years ago, the stock was, I think, in the 90s, and people were saying some pretty negative things about the company's future. Facebook, I alluded to our current hold recommendation, as well as the change that we made at the end of June, on June 27th, downgrading to hold from buy at that point. And then Amazon, we've had a buy opinion on that stock for some time as well. So there are a variety of recommendations, and it really reflects, I think, some of actually what Nick had communicated about the different types of risk that we see related to the very issue that we're talking about. There is pretty significant alignment in terms of what Nick was talking about from a legal and regulatory perspective and our view of the fundamental implications and valuations of the companies and stocks.
Scott, there's a couple more questions targeted for you. The next one, do you think any other companies could or should be in the technology platform company discussion other than those we focused on here today?
It's a question that I actually get pretty frequently because everyone's looking to find, you know, the next Alphabet or Google, the next Amazon. I referenced Spotify in my remarks just earlier, and I think that's definitely a company that has the potential to transition from, I think, what most people perceive as kind of a streaming music service provider to something that can be a lot bigger. I think that's definitely a company to watch, especially since they, as I referenced, probably are poised to benefit because they are not owned by or really inextricably linked to any of the platform providers. And I guess the other company that I would probably be remiss if I didn't reference is when people talk about these technology platform companies, more often than not, they refer to them as within FANG, right? And so the N in FANG stands for Netflix. That's a stock that we've liked for some time. The performance has been very strong. More recently, I think people have taken somewhat of a risk-off approach to Netflix, in part because of some of the concerns related to subscriber growth, but I think they continue to invest very effectively and build out the platform. And so there definitely are a lot of competitors out there. Many of these technology platform companies do have video offerings, but no one does this as well as Netflix from a technology and content perspective at this point, and we have a buy opinion on that stock as well as Spotify.
All righty, we're going to take one last question here for Scott, and for the sake of time. Scott, what is the strategic importance of hardware for the companies you focused on in today's presentation?
Right. Well, how much time do you have, Julian? So what's interesting is that I think of the companies that we've spoken about here today, the only one with a really significant hardware presence is Apple. I think the iPhone accounts for, I'm ballparking it, but well over 2/3 of revenue. I think it's closer to 75% of revenue at this point. As Nick indicated at the top of our discussion, at 1 p.m. Eastern, Apple's going to kick off their new product event, where I'm assuming they're going to introduce a number of different products and services headlined by multiple new iPhones. So I think with that success, I think we've seen other technology platform companies going down this route. Amazon is probably next in line here. They, I think, have been pretty successful with some of their offerings, not necessarily with respect to phones, but tablets they've done all right, and I think people know them for Kindle and what they've been doing with Echo. I think next, obviously, is Alphabet and Google, and they've been trying a lot of different things on the hardware side, but nothing has really been sticking. I think their kind of mobile intelligence speaker offering, that obviously has gained some traction, but other than that, there's really nothing to speak of on that front. And then Facebook, I think honestly, Nick alluded to the fact that the Cambridge Analytica situation came to a head in March. I think around that time they were getting ready to release the equivalent of a next generation smart speaker, which would actually have video capabilities, and so you'd be able to do video chat from the equivalent of a smart speaker. I think they've dialed that back because of all the regulatory scrutiny that I alluded to, and that's one of the risks for these companies as they become less aggressive with respect to not just M&A, but innovation in light of some of these issues.
Great. Thank you, Scott. Okay, everybody. Unfortunately, we're running short on time, so we'll have to leave it there. We will follow up directly on other questions that came in during the call. And on behalf of the team at CFRA, we'd like to thank you for joining us today. Within the next day, be on the lookout. You'll receive a note from us with a link to the replay and slides from today's session. We hope you'll join us again for our next webinar series. Stay tuned. And in the meantime, should you have any questions, please don't hesitate to contact us directly at cservices@cfraresearch.com. Thank you, everybody, and have a fantastic day.